So, ladies and gentlemen, maybe I would ask you to take your seats so we can start our second panel discussion during the conference. We now move towards issues of gender equality under the Convention, and in particular the interaction between Article 8 and Article 14 of the Convention. We will begin with an introductory presentation by Judge Jelic. Subsequent to that, Judge Bianku will intervene. Judge Turkovic is not present, so we will potentially have a bit of an interaction on the themes, and I would also ask some of the other colleagues of the Strasbourg Court to engage in that discussion. We already started to some extent this morning, in particular with references to the case law of the court in relation to Article 14, and it might be an opportunity for us to develop a bit that part of the discussion. But without further ado, Ivana, please, you have the floor.
Thank you, Robert. I hope that you had a good lunch and that now we could continue with our work. I'm going to address you in Montenegrin and English, so in order to give equality to both working languages. U svojoj jurisprudenciji, Evropski sud za ljudska prava je utvrdio da je unapređenje rodne ravnopravnosti glavni cilj u državama članicama Savjeta Evrope. I to je citat iz već citiranog predmeta Konstantin Markin protiv Rusije, koji su pomenuli i predsjednik i naša potpredsjednica. Posebno u kontekstu interakcije između člana 8 i 14, sud je bio u mogućnosti da pruži smjernice o tome kako se može postići suštinska rodna ravnopravnost, ali i šta je neophodno da bi se obezbijedio dostignuti nivo ravnopravnosti u državama članicama i shodno tome doprinijelo postizanju rodne ravnopravnosti. Prije nego što bliže pogledamo konkretnu praksu suda u ovom kontekstu i njegov doprinos postizanju naglašene rodne ravnopravnosti u svim državama članicama Savjeta Evrope, vrijedi, po mom mišljenju, definisati različite koncepte koji su uključeni. Iako je, kao što je istaknuto u ključnim standardima Savjeta Evrope o rodnoj ravnopravnosti, citat, rodna ravnopravnost ključna za zaštitu ljudskih prava, funkcionisanje demokratije, poštovanje vladavine prava i društvenog blagostanja, kraj citata, taj princip nije izričito propisan konvencijom, za razliku od mnogih nacionalnih ustava, kao što je Ustav Crne Gore, koji u članu 18 propisuje ovaj princip, ili nekih drugih međunarodnih instrumenata, kao što su oba međunarodna pakta o ljudskim pravima, međunarodna pakta PGP i PESK u članu 3. Konvencija ipak, prema članu 1, obavezuje države članice da obezbijede svakome u okviru svoje jurisdikcije prava i slobode definisane u odjeljku 1 ove konvencije i izričito zabranjuje u članu 14 diskriminaciju u uživanju prava i sloboda navedenih u konvenciji po bilo kom osnovu, a jedan od njih je i pol. Opšta zabrana diskriminacije predstavlja osnovu za bavljenje suda zaštitom rodne ravnopravnosti, kao što znamo. Član 14 ipak je nesamostalno i sporedno pravo, koje u najmanju ruku zavisi od primjenjivosti drugog prava iz konvencije, ali to ne znači nužno i da nalaz povrede člana 14 zavisi od povrede drugog člana iz konvencije. I to je razlika između akcesorne prirode ovog člana i člana 1 protokola 12 koji se primjenjuje nezavisno i što je jedan od razloga zbog čega ga neke države nisu ratifikovale, kao recimo Njemačka. Konvencija zabranjuje sve vrste diskriminacije, što znači da su i direktna i indirektna diskriminacija zabranjene. Da podsjetimo, i zbog radionica koje će kasnije nastupiti, direktna diskriminacija se dešava kada se osoba tretira različito u analognoj ili relativno sličnoj situaciji na osnovu prepoznatljive karakteristike ili statusa. Ili kada se prema nekom licu sprovodi drugačiji tretman, dakle kada se neko lice tretira slično, iako se nalazi u različitoj situaciji. dok se indirektna diskriminacija dešava tamo gdje, iako predstavljena neutralnim terminima, kao što su neka opšta politika ili mjera, ima poseban diskriminatorski efekat na određenu grupu i često su te grupe upravo žene. Međutim, ne predstavlja svako različito postupanje ujedno i diskriminaciju koja je zabranjena, već samo onda kada ne postoji objektivno i razumno opravdanje za određeno različito postupanje, odnosno ako se ne teži legitimnom cilju ili ako ne postoji razuman odnos proporcionalnosti između upotrebljenih sredstava i cilja koji se želi ostvariti. I ovo je citat iz Mola Sali protiv Grčke, naš predmet Velikog vijeća. Kada je podnosilac predstavke ukazao na različit tretman, na odgovarajućoj vladi je da pruži ovo objašnjenje, obrazloženje. U slučaju različitog tretmana u vezi sa polom, sud zahtijeva od država članica da daju veoma teške razloge. Ovo je bukvalan prevod onoga što kažemo very weighty reasons za različit tretman i smatra da se oslanja na stereotipe kao što su percepcija žena kao primarnih staratelja djece i muškaraca kao primarnih hranitelja ili primordijalna uloga muškaraca i sekundarna uloga žene u porodici kao nedovoljne da opravdaju različit tretman žena i muškaraca. I ovo je također iz citirane presude Markin protiv Rusije. Rodna ravnopravnost znači jednaku vidljivost, osnaživanje, odgovornost i učešće žene i muškaraca u svim sferama javnog i privatnog života. To također znači jednak pristup i raspodjelu resursa između žena i muškaraca i njihovo jednako vrednovanje. Ovo je citat iz publikacije Savjeta Europe o rodnoj ravnopravnosti između muškaraca i žena. Sada, ovo moje uvozno izlaganje za ovaj panel obuhvatit će u nastavku pregled opsežne sudske prakse, ali samo pregled i samo nekoliko kraćih analiza u odnosu na neke predmete koji se tiču odnosa člana 14 i člana 8 konvencije. I potrudit ću se da pokažem koji je doprinos suda postizanju rodne ravnopravnosti u državama članicama Savjeta Europe, tako što ću se osvrnuti na pravo na poštovanje privatnog i porodičnog života, posebno na roditeljska prava i starateljstvo, ali i na seksualna i reproduktivna prava, prava iz radnog odnosa, u vezi sa pristupom zapošljavanju, socijalnoj sigurnosti, blagostanju, beneficijama, imovini i učešću u javnom životu. I na kraju ćemo dati neki zaključak koji u stvari treba da bude uvod za dalju diskusiju. Diskriminacija na osnovu pola i prava na poštovanje privatnog i porodičnog života u kontekstu člana 8 je u stvari odredba u kojoj se najbolje vidi, kao što je sutkinja O'Leary rekla, ta pravna priroda konvencije kao živog instrumenta. To je potencirala i sutkinja Lazarova-Trajkovska i ja bih zaista voljela da vidim nacionalne sudove koji primjenjuju taj koncept živog instrumenta malo više, tako da manje predmeta toga tipa dolazi u Strasbourg. Član 8 obavezuje države članice da obezbijede za svakoga u svojoj jurisdikciji poštovanje njegovog privatnog i porodičnog života, njegovog doma i prepiske. Ovo obuhvata zaštitu i jedinstva porodice, kao i spajanje porodice u slučaju razdvajanja, ali i kontakt prava roditelja i njihove djece ili odluke o pravima starateljstva nad djecom. The case law of the court can thereby be roughly divided in cases where the court was deciding upon an alleged discriminatory treatment of women and the cases upon an alleged discriminatory treatment of men when it comes to parenting and custody rights, which is, or would be, both detrimental to the achievement of gender equality. In the context of discriminatory treatment of men, the court faced some critique that the court itself was risking to reinforce stereotypes which are used to justify the alleged discrimination. In the case Alexandru Enache versus Romania, the court found, for example, that national law allowing to defer a prison sentence until the first birthday of the child, which was only available for convicted mothers, did not violate Article 14 in conjunction with Article 8. Even though the applicant was in a comparable situation, as the female prisoners. The different treatment of men and women in this situation was justified with, quotation, particular bond between a mother and a child during the first year of the child's life. The court thereby did not deny the impact of differential treatment on gender equality, but made it clear that due to the broad margin of appreciation that had to be given to the states were regulating penal policy, quotation, there is a reasonable relationship of proportionality between the means employed and the legitimate aim pursued. And I don't have time to quote more on international instruments, but I would like to stress your attention to UN rules for treatment of women prisoners and non-custodial measures for women offenders, Bangkok rules, for example. In a majority of cases, however, where the court found the discrimination on basis of sex in the context of parental rights, the case concerned the discriminatory treatment of women. The detrimental treatment in question can thereby, on the one hand, stem from the national law and its application. For example, when the national civil law prescribes that the child's surname was automatically the parental surname, followed by the maternal surname in the case of a dispute between the parents, like the case in Leon Madrid versus Spain. As the law in place did not allow the concrete circumstances to be taken into account, for example, the father's initial insistence on convincing mother to terminate the pregnancy, or the fact that the child had borne the mother's surname since birth and for more than a year in the absence of immediate recognition by father, the different treatment of men and women could not be justified. This case was only the latest of cases where the court called for gender-balanced policies when it comes to the family name to overcome the idea of a pater familias presiding the family and holding that the unity of the family could be also preserved by different constellations of family names. Finding a discrimination on the basis of sex is thereby not always easy or undisputed, even by the court itself. The difficulties and different views in finding gender-related discrimination in cases concerning parental rights can, for example, be seen in the recently decided case AM versus Norway. The case concerned the denial of legal recognition of parenthood to an intended mother who had no biological ties to the child, which was born through a gestational surrogacy arrangement abroad. In this case, the majority of the chamber held that there was neither a violation of Article 8 nor a discrimination of the applicant, Article 14, read in conjunction with Article 8. Judge O'Leary, in her concurring opinion, already hinted to the possibility that the case raises questions concerning the discrimination, but that the complaint, quotation, was quite simply underdeveloped and unsubstantiated. I always have a problem in pronouncing this one. And for the reason it was rejected. Whereas in my separate but dissenting opinion, I came to the finding of a violation of Article 8 accompanied by a discrimination of the applicant under Article 14 because the failure to award the applicant with legal recognition of motherhood has resulted in the father retaining sole authority to refuse the applicant any right to visit or stay in contact with the child, granting him the exclusive power to decide over the applicant becoming the mother of a child who was intended to be hers when she had been unable to procreate biologically. This woman took care of a year and 6 months from the birth of the child about this child. This imbalance of power not only leads to one person being able to make life-changing decisions over another person, it can also create a situation where this power can be misused in order to abuse an intended parent. Awarding such large powers to one person, and in this context, men, is not only discriminatory against the parent who was biologically unable to procreate, in this context, a woman, it also acts contrary to the intended purpose of surrogacy and the best interest of a child. This is what I think. The domestic authorities' refusal, furthermore, based on different marital status, which is why the case can be compared to cases where the court has found violations of Article 14 in conjunction with Article 8 of the Convention, where a partner in an unmarried same-sex couple was not allowed to adopt the child of her girlfriend without severing their legal ties. And this is the case in X and others versus Austria from 2013, showing the need to bring the court jurisprudence into on heterosexual couples in line in this context. So you see, we were very close in our reasoning, Shifra, O'Leary, and myself, not other 5 judges, and you can read that, but we decided to actually conclude differently because that was a borderline case. And this is what actually develops exchange, judicial exchange, and this actually gives, I think, power of our judgments. However, the court adds to the achievement of substantive equality throughout its member states by shedding a light on discriminatory law, but also discriminatory practices on national authorities. That discriminatory views are not limited to national authorities, but can also be found in the domestic judiciary, can be seen in particular in the context of sexism. This is conclusion about, in general, not about this case. Concerning sexual and reproductive rights, I'm not going to elaborate more, but just would like to highlight, as our president highlighted, Carvalho Pinto de Sousa Moraes versus Portugal, and also Jurčić versus Croatia. Another emphasis is, by myself, is concerning access to employment, and then I'm going to stop and give, give space to other aspects of interaction between Article 8 and 14. The refusal to hire women has to be justified with reasonable and objective grounds, as it otherwise amounts to a direct discrimination. Such reasonable and objective ground might be given if women were unable to assume a certain task. This, however, needs to be proven. The mere claim that, for example, security officers work on night shifts and have to use firearms and physical force does not suffice to justify the exclusion of women from the respective job. And this is quotation from Boyraz versus Turkey. In the same time, not every change of a post, even if based on ground of pregnancy, amounts to discrimination on the basis of gender, as could be seen in Napotnik versus Romania. Additionally, it is important that also during the employment, there is a special need for the statutes to ensure the protection of women in the work environment and their equal opportunities. This can also entail an obligation to effectively tackle mobbing, bullying, and its consequences, and to not adhere to static or rather mechanical interpretations of the concept concerns, as the court held in Spadier versus Montenegro, where the chamber was unanimous. The court emphasized that, quotation, complaints about bullying should be thoroughly examined on a case-by-case basis, in the light of particular circumstances of each case and taking into account the entire context. In other words, there may be circumstances in which such incidents are less frequent than once a week over a period of 6 months and still amount to bullying, or circumstances in which such incidents are more frequent and yet not to amount to bullying. This is quotation from the judgment. The fact that the mobbing activities occurred over a period of 6 months did not hinder the finding that there was mobbing going on, and the authorities had to provide protection to the applicant from the male colleagues. Besides that, gender equality must be observed in the context of work-associated welfare programs, benefits, and social security entitlements, but that we can leave for the discussion in workshops. And a short conclusion, if this topic could be concluded. Na početku sam ukazala na različite dimenzije, materijalne, suštinske jednakosti, u namjeri da pokažem kako je sud u svojoj praksi povodom međusobnog djelovanja članova 8 i 14 doprinio i još uvijek doprinosi unapređivanju rodne ravnopravnosti. U nekim predmetima, kao što je Vilis protiv Ujedinjenog kraljevstva, vidjeli smo da sud ispravlja nedostatke i na taj način obezbjeđuje distributivnu dimenziju jednakosti. Sud se dalje bavio stereotipnim zakonima i njihovom primjenom, kao i stigmatizirajućim praksama nacionalnih vlasti, kao što smo vidjeli na primjerima Jurčić protiv Hrvatske ili Carvalho Pinto de Sousa Moraes protiv Portugala, i time aktivno doprinio dimenziji priznavanja šta znači rješavanje stigme, stereotipa, predrasuda, nasilja, bacajući svjetlo na tekuću praksu i njihov diskriminatorni ishod. Kao što se može vidjeti na primjeru predmeta Mizi protiv Malte, na primjer, svojom jurisprudencijom o važnosti jednakog pristupa sudu i pravu na pravično suđenje u krivičnom i građanskom postupku, Evropski sud obezbjeđuje da osobe koje su pogođene diskriminacijom mogu efikasno da se bore protiv diskriminacije koja im se dogodila. Sud na taj način također doprinosi dimenziji učešća u ostvarivanju suštinske jednakosti, gdje je omogućeno jednako učešće svih polova. I na kraju, sud kroz svoju sudsku praksu podstiče strukturalne promjene, kao što je na primjeru predmeta Ditricio protiv Švajcarske, i zahtijeva da država članica ispuni transformativnu dimenziju suštinske jednakosti tako što će prilagođavati svoje nacionalne zakone i praksu evropskim standardima. Stoga se može zaključiti da je jurisprudencija suda u Strasburu povodom interakcije članova 8 i 14 značajno doprinijela i još uvijek doprinosi naporima i težnji Savjeta Evrope i njegovih država članica da postignu suštinsku rodnu ravnopravnost. Ostajem na raspolaganju za sva vaša pitanja i u toku panela i kasnije tokom ove konferencije. Hvala vam.
Thank you very much indeed, Ivana. Before giving the floor to Judge Bianku, to Ledi, I think it is useful at this point to contextualize a bit the debate we are going to have and are having on Article 14 and Article 8, also from the perspective of the regional normative context. Because what is interesting about this region is the extent to which states in this region, every one of them, with the exception of Bulgaria, have ratified Protocol 12. That is rather unique regionally in the Council of Europe legal space. Most of the states in the region ratified Protocol 12 in 2002 up until 2004, which sufficed for Protocol 12 to come into force exactly 17 years ago, 1st April 2005. So when we are talking about Article 14 and 8 within the European Convention on Human Rights, we mustn't forget that Article 14 in and of itself is what we call a parasitic provision, which always requires for its application that a complaint falls within the ambit of a substantive provision. And when it comes to Article 8, the right to private life and the right to a family, we are, of course, in an area where usually states are very much dealing with issues of social and economic rights, and also Article 1 of Protocol 1. So the court is often quite challenged in applying Article 14 in that context. Konstantin Markin is, of course, the most celebrated example of this. That was a parental leave case. One could have made the argument, potentially, that that case was really only meant to be dealt with under Article 8, or even questioning whether Article 8 was applicable in those circumstances for the purposes of Article 14. But when it comes to the region, it is very important for the judges and the practitioners to bear in mind the enhanced tool under Protocol 12, which is the general prohibition of discrimination, which does not require any connection or a nexus with the substantive rights under the convention. And I think we should try to explore that a bit and maybe get some of my colleagues. Vice President O'Leary knows a lot about this stuff. She may want to comment on this. And there are a lot of issues which arise when it comes to this interaction between 14 and 8, also in relation to Protocol 12 and the rather underdeveloped case law we have because of the scarce number of ratifications. Ledi, please.
Thank you, Mr. President. Well, before starting, let me reply to the point you raised about the countries in the region signing and ratifying Protocol number 12. I had the chance to be in Rome in November 2000 when Protocol number 12 was signed in the 50th anniversary of the convention, in the summit. And immediately after the summit, I approached the Albanian foreign minister at the time. He signed, he submitted the signature documents. And I approached him and I asked, Minister, have we assessed duly our capacities to implement Protocol 12? Because the impact is huge. He said, not yet, but we'll do it before ratification. I doubt Albania or any other country in the region has done such an assessment before the ratification of Protocol 12. And this was shown as well on the famous case of Sejdic and Finci versus Bosnia and Herzegovina, which is the first case so far, and probably one of the most important on Protocol number 12. Now I start with what I had the intention to start before replying to the President. Let me just express my pleasure and my thanks to the organizers for having invited me to this extremely important event. Let me also express my thanks and gratitude to both Ivana and Hannah Smith for the guide. I already have had the chance of hearing some comments by the national authorities how important the guide is already before sending the guide to their collaborators in the specific countries. So very well done. On my comments on this topic, I'm not going to make a long speech. So gender discrimination under Article 8 and 14. As a brief introduction, let me just recall some of the main aspects of this debate. Gender and sex discrimination under Article 8 and 14 are one of the grounds for which the margin of appreciation of the states is stricter compared with all other grounds. Racial discrimination also is very strict. This should be borne in mind by all those who interpret these provisions and the pertinent situations. And the court has said that only very strong grounds, very strong reasons can justify a discrimination on the basis of sex. So this should be kept into our minds. Also, the court has said that, as mentioned by many of those who spoke before me, tradition, history, culture does not suffice. So this is an argument which is not sufficient for the purpose of justifying discriminatory treatment. As well, gender discrimination, sex discrimination might require positive measures in the treatment, not only domestic violence, for example, where it is an ad hoc situation, but also generally, as it is the case of Katol II versus Russia, the prisons, life imprisonment for men and women in Russia. Now, as Ivana just said, for Article 14 to apply, the circumstances of the case must fall within the ambit of Article 8. And here starts, I have a few points. Here starts my first point I want to underline. In the region, but not only, the President mentioned this morning the stereotyping. And this is found, the problem of stereotyping, in relation to both articles of this tandem, both in relation to Article 8 and in relation to Article 14. For example, there are many countries many governments before the court as well, who argue the specific elements of life of a person do not fall under private life or family life because of these historical, traditional, and etc. elements. So there we have the first stereotyping. For example, Untitled versus Turkey. Turkish government was arguing that, well, the applicant had already the last name of her husband when she started to practice as lawyer, but they didn't expand the notion to her private life besides the professional life. So there you see a problem in understanding the the scope of Article 8 in these circumstances. And in addition to that, we have the second stereotype, which is related to Article 14. Many speakers before me, they said that the role of women in our societies is considered as different from the role of men. And this is considered normal. Coupled together, added to each other, these both stereotypes bring to situations which are extremely problematic under the convention. In relation to this kind of stereotype, the best case was the one just mentioned by President Spano, Konstantin Martin. Their traditional family was out of kind of any imagination for Russian men, in addition soldiers, to leave their duty and take a parental leave. The second point I want to make is somehow the relationship between Article 8 and 14 with other articles of the Convention, and somehow I'm making the relationship with the session of this morning. This morning's session, you mentioned cases like Opus, Talpis, Kurt versus Turshana, but Turshana is somehow kind of different on the circumstances. And in all these cases, the struggle has been how to apply the Osman test in the family relations. And here is my point. In many cases where you have an Article 2, mostly, or 3 issue that we discussed this morning, this is the continuation, and even I might say the consequence, of an Article 8 plus 14 issue. I would say it is rare for domestic violence to come out of the blue. Usually you have a history of offenses at home. Little, if I can qualify it, violence, which then later degenerates to big violence and even loss of life, as it was the case in Opus. Here the difficulty is where the duty of the authorities lies in order to intervene. And that is a topic that our president has raised in the case of Talpis versus Italy, because it's not an easy test. Because of course the obligation is different, Article 8 and Article 2 or 3, but where do you find the right moment? And here I bring, because this I don't think was mentioned so far, another element or another perspective of the stereotype, which is the position of women, the way the women understand their role and their position in the family by reacting immediately to any single case of violence of whatever form that might be, before the situation going too far. My third point, the understanding of these concepts that are key to avoiding discrimination under Article 8 and 14 is not static, is indeed evolutive. It evolves with time. This is true not only for Western Balkan societies, but for all modern societies, as Shifra mentioned this morning. I can also say that Article 8 concepts have been subject to the criteria of evolutive interpretation more than any other article of the Convention. And this is exactly because these concepts are very much part of what we consider the approach of historical elements, tradition, societies, and our societies in Europe have evolved tremendously for the past 70 or so years. So we have to be all at national and European level very careful when we interpret the term, for example, consensus. Same-sex couples, for example. This was not a consensus 20 years ago, now might move. I recall, for example, the case of X and others versus Austria, where the court was very careful because it said, that is the situation now, but might not be the situation in 10 or 20 years' time. So this is very much evolutive. And I'll come back to this point later. My fourth point is a point related very much to the methodology used by the court, and the title I've given to this point is From Abdulaziz to Tershana. Cases deal with different articles. Abdulaziz, Cabales, and Balkandali 1985 case deals with Article 8 plus 14. Tershana deals with Article 2. But I want to underline the methodology used by the court. In the famous case Abdulaziz, the British government argued that the notion of the historical and traditional concept of family in the UK should have justified that for British men being joined by their wives of a different nationality in UK soul was accepted, but not vice versa, for a British woman to be joined by a man of another nationality. And the court did not accept this argument. So the situation in the ground, the historical, the concrete circumstances were not accepted by the court to justify a difference in treatment. Now, what happens in Tershana? President and I were together in the same panel dealing with this difficult case. And the circumstances were explained this morning. The situation in the ground, the tradition, the reports by NGOs, international organizations, national organizations, as to the attack by acid, or in general, attacks to women, were used in another way by the court to say that, hey, here the situation is problematic. So you have to add to your investigation this important nuance of possible gender attack based on gender. So you see how the situation in the ground might kind of be turned around in order to protect better the rights of women. My conclusion is on 2 points. First, I would say that gender issues are one of those issues, probably the most evident one, that help towards cultural and societal integration in Europe and especially in the Balkans. By understanding in the same way the role of women in the society, our societies are better integrated, not only at European level, but also at national level. Yesterday, I was speaking with 2 Albanian judges who told to me how different is the perception of many issues between Vlora and Fier. How far there? 60 kilometers? So you can imagine. This is the situation very much in the region. The perception between the capitals and the villages is completely different. So you have to make sure the integration of your societies at that level. Strasbourg would look as the Montenegrin society, Albanian society, Bosnian society. But you have to take care of these nuances within your societies. And then is the role of national judges. As said, the notions under Article 8 and 14 are not understood in the same way by everyone, not always in the same direction, not always with the same speed. are national judges who should really integrate and make possible their kind of common understanding and as much as possible in compliance with European standards. When I say in compliance with European standards, and I still have X and others versus Austria in mind, I would maintain, I would suggest, that national judges can conduct themselves a consensus test of the situation in Europe before the case going to Strasbourg. For the Strasbourg court to decide might take years. If we speak about subsidiarity, you have to use the instrument that the court uses before at national level. And my final point is with the quotation. Some 20 years ago, a famous professor of international law, Martti Koskaniemi, published a book about international law with the title, The Gentle Civilizer of Nations, which is a wonderful kind of manual on international law. I would say gender issues and the role of national judges in relation to gender issues are somehow the gentle civilizer of societies. So your role is crucial in that civilization. Thank you very much.
Thank you very much, Ledi. Before now opening up the discussion, I thought I would just very briefly, because President Čakanimani of the Constitutional Court of Kosovo talked about the test to be applied in these cases, and also to react to Biljana Braithwaite's request that we try to sort of put things forward in as practical a manner as possible. Let me just very briefly go through the 5 elements which you would have to, as judges, look to under our case law when it comes to a claim that there has been discrimination on grounds of gender for the purposes of a right guaranteed under Article 8 of the Convention. The first issue to decide is, does the measure or the alleged disadvantage constitute one of the modalities of the exercise of a right under Article 8? This is the Ambit Test. And this is set forth, for example, in Konstantin Markin. You can look there at paragraph 129. It is a flexible test, so it is quite open for application in light of the way in which the court has applied Article 8, which has, one, a rather flexible concept of family life, but also quite a flexible concept of private life. So does the allegation, does the male who alleges that he does not have access to parental leave, is he or she exercising, does this disadvantage constitute one of the modalities of the exercise of his family life interest or right? And as the court said in Konstantin Markin, the answer is yes. And if the answer is yes, Article 14 is triggered because of the nexus between Article 14 and this is the Ambit Test. Step number 1. Step number 2 is there a difference in treatment? Are the situations being compared, analogous, or similar? And the test, I think, maybe my colleagues will disagree with me, but I think the test that I would normally refer to now is from a case called Fabian versus Hungary of 2017. And you look there at paragraph 121, and there you would ask, are the elements that characterize the difference between the alleged treatment one that is differential if you look at the purpose of the difference? What is the purpose behind a man not having parental leave and a woman having such leave? What is the difference between a law that says only males can get life imprisonment and females not? What is the difference between a law that says a widower will not have a benefit from the state after the child has reached the age of 18, whilst a widow would. What is the purpose and nature of that distinction? And then on that basis, one would come to a conclusion whether there has been a difference in treatment. That's the second step, comparability. You compare the two, and Fabian versus Hungary, paragraph 121, is probably the test you would look to. The third part, there is a difference in treatment. Then the third step is the difference in treatment based on objective and reasonable grounds? Is there a reasonable relationship of proportionality between the means employed and the aims sought to be achieved? This, again, is from Konstantin Markin and many other cases, paragraphs 124 to 128. There we have, that's the most tricky part for any judge. If you've gone through the first step, the second step, and the third step, what are you looking at in this third step in relation to proportionality? The first question for us to ask, and this is the fourth element that I would highlight, is how strictly are you looking at that as a judge? Because you're looking at a measure which has been probably legislated upon by a parliament. How strictly are you looking at the issue? And we call this, as you know, the margin of appreciation. And there, of course, there can be a difference between the margin afforded by us in the Strasbourg court, because we are looking at it at the international level, whereas a judge of a constitutional court or a Supreme Court may be looking at the margin of appreciation in a different light from the perspective of national constitutional law and rules of judicial review. But overall, if the difference in treatment, I like very much Vice President O'Leary's but for analogy, so but for the difference in treatment, or but for the subject of disadvantage, the two categories would be equal. How does the government justify that difference? And there you have, clearly under the case law, that if the difference in treatment is based on, like in Konstantin Markin, based on gender, that is the ground, or like in Kamtoku versus Russia, based on gender, or like in a pending case we have now, Baylor versus Switzerland, or in the older case mentioned by Judge Jelic, Ditrizio versus Switzerland, gender is the defining characteristic between the subject matter. Then the convention teaches scrutiny by the judge is very strict. It will only be accepted if there are very weighty reasons for that distinction. That puts the judge in a very strict review-based posture of requiring very strong argumentation on behalf of the government. The final point before I stop is the issue of the burden of proof. Who has, at the stage of justification, to bear the burden of proof? And here I agree with what Vice President O'Leary said, also from the perspective of systemic discrimination. The court is not always very clear on this issue. Now, let me just express what I think to be maybe the more solid and cogent response to it. The applicant has the burden of demonstrating, one, that the complaint constitutes one of the modalities of the exercise of the right, the first test, the ambit. The applicant also has to demonstrate, at least at the prima facie level, that there is a difference in treatment. But when the difference in treatment is recognized, then more or less the burden shifts to the government to justify the difference. Now, of course, it's difficult to say that it is a complete shift in the burden of proof, because, of course, an applicant will demonstrate to some extent in pleadings that the issue is one of differential treatment. So these would be the 5 elements of the test that I would highlight, and case law which you could rely upon in dealing with an issue under Articles 8 and 14. But again, as I mentioned, with the exception of Bulgaria, in the Balkans, you will be confronted with potentially a claim under the general principle of non-discrimination under Protocol 12. Now that, of course, can be a different legal analysis in some respects to the one that I just highlighted, which is very much the classical analysis under the convention, because we are usually, most cases, we are dealing with an Article 814 challenge rather than a pure Protocol 12 challenge. So the floor is open. Do maybe one of my colleagues want to add something to this sort of overview before we continue with questions and comments? Or we can come back. Shifra, please.
You've outlined the test so beautifully, there's little to add. However, in relation to Article 8 and 14, as you say, the applicability question is very, very important. The court, for the reasons explained by Lady Bianku, is often accused of mission creep, of extending the scope of application of the Convention, and Article 8 is one of the articles under which, in relation to which we're particularly criticised. So when we're looking at the applicability question, we are also trying to respect the limits to the application of Article 8. The other point I would make is that we talk about gender equality in the title, but Article 14 isn't naturally a substantive equality tool. It's a very basic non-discrimination provision, which is more limited, and even more so, the Convention drafters, they conceived of it as a sort of add-on, a subsidiary article which only comes into play after the others, which means that in our case law, we sometimes don't examine Article 14 if we found a violation under the substantive provision. It is one of the weaknesses that I referred to this morning and which the President has picked up on. If you look at the terms of Protocol 12, they're very different. That is more a substantive equality instrument. And the difficulty for the court, remember, is that we do get cases from this region and other countries which have ratified Protocol 12, but we have to make sure that our Protocol 12 jurisprudence doesn't lead us to interpret Article 14 in a manner which transforms it into a substantive equality instrument in relation to all those states that haven't ratified it. We have to respect the limits of the Convention. One of the things that I thought was useful for us to reflect on either in this question and answer session or the other panels is gender equality, Article 8 and 14. If you look at the fact sheet of the court on gender equality, the subject matter is absolutely vast. So I think one thing that you might want to do is focus on where can you have most traction within this region. I would suspect that that is focusing on the issue of employment and probably social security and social welfare, because that's how you transform women's status and stature within society. I add a personal anecdote in this regard. I'm the daughter of a woman who in Ireland, when she got married, had to stop working by virtue of a marriage ban imposed on all women who worked in the public sector. Silently, that transformed her into a gender champion for her 3 daughters and her 3 sons. Silently, she brought us up to A, have a voice, like the Commissioner emphasized this morning, but also to live knowing that we had an equal voice. In my society in Ireland, we had one very famous gender champion. She became the President of Ireland, the first President of Ireland, Mary Robinson. Throughout the 1970s, she brought cases strategically to the 2 European courts, the court in Luxembourg and the court in Strasbourg. She chose her applicants, she worked for free, and she changed both my society and she changed the jurisprudence of the European Court of Human Rights in very, very important cases like AIRE against Ireland and Norris against Ireland. So one of the things I think that you should also discuss, perhaps your conversation in this regard is already very, very well advanced, is strategic litigation. This morning, the President referred to the fact that, ironically, Konstantin Markin, the applicant, is a man. There's no irony. Ruth Bader Ginsburg chose male applicants in order to bring cases before male judges or traditional courts and show them that equality is a male-female issue. Mary Robinson did exactly the same thing in Ireland. Her applicants were male and female in order to change the culture and to render the legal instruments available at European level more effective. She went outside the island of Ireland to change domestic law because the domestic courts were excessively conservative. So my two suggestions, if we want to discuss this further later on today or tomorrow, is focus on what we can achieve with Article 8 and 14, and perhaps employment is one of the best areas. Discuss strategic litigation. And of course, then there is another source of inspiration, which our court uses very, very regularly, which is EU law. EU law, which in the field of employment and social welfare is much more advanced than the European Court of Human Rights, because they have such an extensive body of secondary legislation. So some of the cases that we've been discussing this morning, and which are referenced in the case law guide, they are inspired by EU Luxembourg jurisprudence, Coleman on discrimination by association, or a case called Meyer, which was the IVF case, which the President mentioned this morning. And I leave you with a final personal anecdote in relation to that case, of which I'm very proud. I drafted that judgment when I was a young lawyer in the Court of Justice in Luxembourg. I was at the time expecting my second child. And the other case lawyer working for the Advocate General was expecting her first child. So at the hearing in Luxembourg, you had two pregnant women working on a pregnancy case, and I thought it was a certain beautiful legal poetry involved. Thank you.
Thank you very much. We have now about 20 minutes. President Tadić, please.
Hvala, gospodine predsjedniče. Dopustite da prvo kratko dam osvrt na protokol broj 12 koji ste vi pokrenuli pitanje. Pred sobom imam listu država koje su ratificirale, odnosno koje nisu, država koje su potpisale. I zapažam, kao što i vi znate, među mnogim državama koje su osnovale Vijeće Europe, koje su prihvatile Europsku konvenciju 1950. godine, odnosno primjenu 1953. nisu ratificirale ovu konvenciju. Na primjer, evo kad pogledam abecednim redom, nije ratificirala Austrija, Azerbejdžan, Belgija, Bugarska, Češka republika, Danska, Estonija, Francuska, Njemačka, Grčka, Mađarska, Island, Irska, Italija, Latvija, Lichtenstein, Litvanija, Ujedinjeno kraljevstvo i tako dalje, Poljska i tako dalje. Mislim da je sudac Bianku ukazao na jednu stvar kada je pitao svog ministra, kako sam shvatio, jeste li spremni za ratifikaciju. Mnoge države, uključujući moju državu iz koje ja dolazim, nisu uopće bile svjesne protokola broj 12 šta on znači. I da li su spremne da ispoštuju protokol broj 12. Pojavio se slučaj pred vašim sudom, Sejdić-Finci, a da je pravilno se rezoniralo i razmišljalo. Bosna i Hercegovina je prvo trebala izvršiti ustavne promjene, pa tek onda potpisati, ratificirati protokol broj 12. Ovako je vaša odluka donijela katastrofu, tako zbunjenost da ona se ne može provesti i ne provodi se više od 10 godina. Jer nije promijenjen ustav. I onda neki političari dođu pred Ustavni sud i kažu, pa utvrdite i vi povredu i promijenite ustav. A ja kažem, čekajte, molim vas, vi tražite od nas da mi budemo ustavotvorci, da mi donosimo i mijenjamo ustav. Znači, mi ćemo uvesti diktaturu Ustavnog suda. Pa će on zakone mijenjati, i ne samo zakone, nego i ustave. Zašto postoje druge grane vlasti, zakonodavna i tako dalje. To je samo osvrt koliko je nepripremljeno, mnoge države su ratificirale, a sad ne mogu da je implementiraju protokol broj 12. Međutim, ja sam htio prije svega da se osvrnem, i najavio sam u diskusiji prije ručka, na ravnopravnost polova kroz jedan konkretan slučaj gdje je u pitanju primjena domaćeg zakona. Naime, pred Ustavnim sudom Bosne i Hercegovine postavilo se pitanje diskriminacije u svezi sa pravom na pristup sudu, zatim članak 8, normalno u vezi sa člankom 14. Naime, radilo se o predmetu u kojem je apelantu bilo onemogućeno, a apelant je bio muškarac, da pred nadležnim sudom tužbom pokrene postupak radi razvoda braka. Osporenom odlukom redovnog suda je zaključeno da je apelantova tužba nedopuštena u smislu odredaba, nije bitan članak, porodičnog zakona Federacije BiH, kojom je propisano da muž nema pravo na tužbu za razvod braka za vrijeme trudnoće žene ili dok njihovo dijete ne navrši 3 godine života. U konkretnom slučaju apelant je podnio tužbu u vrijeme kada je njegova malodobna kćerka nije imala navršene 3 godine života. I on je tvrdio da je diskriminiran kao muškarac u odnosu na ženu, budući da ona ima pravo na razvod u svako doba, a muškarcu je to pravo ograničeno. Apelant je također istaknuo da je ženi omogućen razvod braka u svako doba i mogućnost zaključenja novog braka, dok su mužu, odnosno muškarcu, to pravo ograničena, te u razdoblju od 3 godine ne može zaključiti novi brak jer se ne može razvesti. I sada netko je već od vas govorio, postavilo se pitanje zašto je zakonodavac tako utvrdio normu? Koji je ratio legis različitog postupanja? Mi smo tada zatražili da se izjasne na apelaciju parlament koji je donio zakon, da se izjasni vlada, da se izjasni ministarstvo koje je predložilo taj zakon. I sad od svih njih ministarstvo je dalo opširan odgovor, parlament se nije ni izjasnio, ni ništa nije komentirao, ali ministarstvo je istaklo da se to radi u interesu zaštite djeteta i žene majke. Navedeno je da je tom odredbom željelo se osigurati prisustvo oba roditelja u najranijoj životnoj dobi djeteta, uzimajući u obzir specifičnosti i psihičke promjene koje uzrokuje razdvajanje roditelja u vrijeme kada dijete još nije dovoljno odraslo da shvati određene pojave u društvu. Dalje, ministarstvo je ukazalo na specifične materijalne prilike u kojima se nalaze žene u našem društvu, a koje se ogledaju u tome da su one nedovoljno situirane da bi samostalno opstale s malodobnim djetetom, zbog čega je nužno prisustvo oca. S tim u vezi je navedeno da velik broj žena majki nema stalan izvor prihoda, odnosno da su nezaposlene jer u toj životnoj fazi nisu u mogućnosti raditi velik broj poslova, a ukoliko su u radnom odnosu postoje problemi oko ostvarivanja naknada za vrijeme njege djeteta. Imajući u vidu navedeno, Ustavnom sudu se postavilo pitanje ukazuje li obrazloženje ministarstva na razumno i objektivno opravdanje za različit tretman supružnika prema odredbi članka 43 porodičnog zakona, a u smislu standarda koje propisuje Europska konvencija. U vezi s tim, Ustavni sud je istakao sljedeće, da je nesporno da predmetna odredba ograničava pravo muža na razvod braka za vrijeme trudnoće žene, odnosno dok njihovo dijete ne navrši 3 godine života, a to pravo nije ograničeno ženi majci. Međutim, prema mišljenju Ustavnog suda u realnom životu, čak i uz postojanje navedene odredbe, ne može se spriječiti da muž, odnosno otac djeteta, i bez razvoda fizički napusti majku i dijete. S druge strane, Ustavni sud zapaža da Obiteljski zakon ima niz odredaba koje precizno reguliraju koja su to prava i dužnosti roditelja u pogledu staranja i izdržavanja njihove djece. Dalje, Obiteljskim zakonom su regulirana i pitanja izdržavanja bračnog partnera koji nema dovoljno sredstava za život. Stoga proizlazi da se razlozi i svrha odredbe članka 43 tog zakona koje je ministarstvo navelo u svom odgovoru kao opravdanje ne može prihvatiti. Dakle, ne postoji zakonska prepreka da se u skladu sa drugim odgovarajućim odredbama ovog zakona zaštiti interes djeteta, pa čak i žene, majke, ukoliko postoji potreba za takvom zaštitom. I Ustavni sud nije prihvatio obrazloženje koje je dalo ministarstvo kao razlog za takvu odredbu u zakonu. Mi smo zaključili da takva odredba zakona ne zadovoljava potrebnu zakonsku kvalitetu. Dakle, išli smo u ocjenu kvalitete zakona. U mjeri u kojoj bi se poštivali standardi iz članka 2.4 Ustava, koji također naš Ustav zabranjuje izrijekom diskriminaciju, a u vezi sa člankom 14 Europske konvencije, odnosno u vezi sa pristupom sudu, a tu je pokrenuto i pravo na pravično suđenje. Na temelju navedenog Ustavni sud odlučio da je u konkretnom slučaju apelant diskriminiran prema spolu u svezi s pravom na pristup sudu, te da je navedena zakonska odredba diskriminirajuća jer dovodi do različitog tretmana apelanta prema spolu, a da za takav različit tretman nema razumnog i objektivnog opravdanja. Kao posljedica takve naše odluke kojom smo mi naredili parlamentu i vladi da uskladi sa standardima koji smo iznijeli u našoj odluci, a koji se pozivaju na standarde Europskog suda, rezultat je bio da je parlament brisao ovu odredbu iz zakona, dakle promijenio je zakon i doveo u ravnopravan položaj muža i ženu u korištenju i ovog prava, to je pravo na razvod, odnosno prekid bračne zajednice. Ovdje ću stati da mogu i drugi razgovarati i govoriti, iako imamo jedan interesantan slučaj koji se odnosi na radno pravo, što je čest slučaj u diskriminaciji. Ali neka neko drugi još uključi se. Hvala vam.
Thank you very much indeed, President. May I ask for other comments, please, sir?
Thank you, President Spano. Ja sam Mira Šadović, za one koji me ne poznaju. Zaposlen sam u Vrhovnom sudu Crne Gore i vrlo kratko ću se fokusirati na ovu temu. Potpuno se slažem sa ovom Matovom observacijom i zaista najrazvijenije zemlje nijesu ratifikovale protokol 12 i onda se postavlja pitanje da li je primjereno ili je pak licemjerno insistirati na one druge zemlje koje su to učinile da se pridržavaju protokola 12. Ali sve u svemu, ovo je pitanje o kome mi razgovaramo, bilo da govorimo o diskriminaciji u smislu člana 14 ili u smislu protokola broj 12, jedno izuzetno interesantno i teško pitanje za nacionalne sudove. Zaista se može postaviti pitanje koliko nacionalni sudovi imaju kapaciteta da se bave sa ovim pitanjem i da li smo na pravi način locirali rješavanje ovih predmeta. Gledajte, odmah poslije prihvatanja ovih standarda, odnosno poslije ratifikacije međunarodnih dokumenata, krenulo se u izradu nekog zakona o antidiskriminaciji. Ne bi mu se imalo šta zamjeriti u materijalnom smislu, ali čini mi se da ima razloga za razmišljanje kad je u pitanju nadležnost sudova, da li oni sudovi koji treba da odlučuju imaju kapaciteta da rješavaju ova pitanja. Ovo je materija koja je dodijeljena najnižim sudovima. A radi se o izuzetno teškoj materiji. I nije to samo problem ovoga člana, nego problem i nekih drugih članova. Evo, pričali smo i danas smo se dotakli člana 3, pa molim vas, lijepo neko se obrati tužbom za naknadu štete zbog torture, a istovremeno se obraća Ustavnom sudu Crne Gore i kaže da mu je radnjom nekog državnog organa nanijeta ova povreda, pa onda dva suda dosude naknadu štete. I redovni sud i Ustavni sud. Evo gledajte kakve su te situacije. Mislim da je vrlo bitno pitanje, sudija O'Leary ga je pomenula, to je pitanje zapošljavanja žena i pitanje penzionisanja. Gledajte, mi, ustručavat ću se da ne komentarišem ovo pitanje, bez uopštim naznakama ću o tome da pričam, jer ćete sigurno dobiti taj predmet gore u Strasburu, taj ćete predmet da dobijete, ali gledajte, u našem penzionom zakonu imamo takvu situaciju da je rečeno muškarac ide u penziju sa 66 godina, a žena može da ide u penziju sa 64 godine i toliko staža. To je odredba koja je uvela afirmativnu akciju. Ona je uvela afirmativnu akciju na način što žena može poći u penziju i ranije u odnosu na muškarca ako ona to želi. Ali mi to nećemo tako da tumačimo, nego izvrnemo afirmativnu akciju na drugu stranu i kažemo, sad ćeš ti mora da ideš u penziju sa 64 godine. Da ja ne bih o ovome dalje pričao, jer sam im rekao tamo gdje sam imao da im kažem ovim povodom, šta hoću da kažem? Afirmativnu akciju, još jednom ponavljam, obrnemo diskriminaciju. Kroz pogrešno poimanje uslova za sticanje nekog prava. I neću dalje da pričam, neću konkretno da pričam, sigurno ćete dobiti ovaj predmet ako ne bude zaustavljen na nacionalnom nivou od nekog drugog. Eto, toliko.
Yes, please, madam.
Ponovim, ja sam sudija Lidija Đukić iz Ustavnog suda Srbije, gde sam sudija oko 2,5 godine, ali sam pre toga bila oko 10 godina sudija Vrhovnog kasacionog suda Srbije. Nisam mogla da odolim u ovom momentu i morala sam da se javim za reč, zato što kolega Radović je pomenuo problem koji smo mi već imali. Znači, potpuno identičan problem. U pitanju je ta situacija gde je i kod nas Zakona o penzionisanju bilo predviđeno da žene, zaposlene žene, mogu da idu u penziju ukoliko žele par godina ranije u odnosu na onaj period, kod nas je to 65 godina života, kada moraju da idu u penziju. I onda se desila jedna veoma ozbiljna stvar, da je sama država donela jedan zakon gde je htela da smanji broj zaposlenih u javnom sektoru i onda je u tom zakonu bila odredba kojom je rečeno da će prestati radni odnos svim ženama zaposlenima u javnom sektoru, a to je u Srbiji ogroman broj žena jer je javni sektor zdravstvo, obrazovanje, informisanje, kultura i tako dalje, sve ono što je država osnovala, a većinu toga jeste. Znači, trebalo je ex lege da idu u penziju po toj odredbi iz Zakona o penzijskom osiguranju, koja njima zapravo, kao što kolega Radović reče, daje pravo izbora da idu ranije u penziju par godina ako žele, ako hoće. Ovim zakonom država je u stvari negde izabrala umesto njih, pa je stavila jednu odredbu gde je njima morao da prestane radni odnos. Bilo je mnogo protesta u javnosti i desila se intervencija tada Ustavnog suda, to je 2016. godina, kada je ta odredba zakona proglašena neustavnom. Inače, Ustavni sud je tada uradio nešto što retko radi, doneo je privremenu meru i sprečio je primenu celog tog zakona, tako da se nije dogodila primjena ni na koga. Ali, i sad recimo, to je neka pozitivna stvar. Naravno, loše je kad država radi diskriminaciju po bilo kom osnovu. Znači, te neke diskriminacije druge vrste, ja mislim da svi sudovi u regionu imaju kapacitete da se sa njima izbore, ali kad se dešava ta sistemska diskriminacija gde državni organi i država i njeni državni organi učestvuju, to je onda neki mnogo veliki problem i nije lako, naravno, sudijama da se sa time bore. Naprimer, kad imaju ispred sebe neki zakon koji ima neke diskriminatorne odredbe. Kažem, dobra je stvar bila što je Ustavni sud intervenisao, ali loša stvar se tada desila i to traje negde do danas, što je ta ideja, loša ideja, pogrešna naravno, da žene mogu da idu u penziju ranije, bila dobro primljena kod mnogih poslodavaca. I onda se desilo nešto i dešava se i danas, da su mnogi poslodavci, a Srbija kao, pretpostavljam, i druge zemlje regiona ima problem još uvek sa tranzicijom i tako dalje, i mnogi poslodavci, mnoga privredna društva sprovode te postupke utvrđivanja tehnološkog viška. Onda su poslodavci mnogi, donoseći te svoje programe rešavanja viška zaposlenih, imali odredbe u tim aktima, zapravo jednu odredbu, da će se proglasiti za tehnološki višak žene zaposlene kod tih poslodavaca koje mogu da idu u penziju po tom ranijem privilegovanom uslovu. Znači, sad smo dobili situaciju da su opet poslodavci izabrali umesto tih žena da li će ići ranije u penziju ili ne, pa su ih proglašavali za tehnološki višak i prestajao im je radni odnos po tom osnovu. I na taj način one su bile potpuno oštećene zato što, uprkos činjenici da su uspevale u sudskim postupcima, znači one su u sudskim postupcima, koliko ja znam, a znam, i Vrhovni kasacioni sud je 2018. godine imao te predmete, dakle one su uspevale i sudovi su tu odredbu proglašavali diskriminatornom i utvrđivali da su tužilje žene iz tih predmeta bile diskriminisane po osnovu pola, pa i starosti, ali nisu one imale mnogo od toga, od tih presuda, zato što su ti predmeti trajali 2 godine, 3 godine, 4 godine i onda je došlo ono vreme da su one navršile 65 godina, pa su morale da idu u penziju i nije bilo mogućnosti da se vrate kod poslodavca i da rade još tih nekoliko godina. Znači, to je nešto što ne pogađa veliki broj žena, ali izvestan broj žena naravno pogađa i uprkos činjenici da je Ustavni sud objavio u Službenom glasniku svoju odluku i rekao da je prvo država, onim zakonom, povredila ustavno načelo iz člana 15 Ustava koje utvrđuje rodnu ravnopravnost i da je povređeno i član 21 našeg Ustava koji zabranjuje diskriminaciju. Znači, uprkos svemu tome i da je to publikovano, dešava se u praksi da se ignoriše i ta odluka Ustavnog suda i mnoge druge i da i dalje žene bivaju diskriminisane, iako, kako da kažem, u ovoj situaciji sudovi su jedna svetla tačka u svemu tome. Hvala lepo.
Thank you. One more, and then I want to give the panelists the opportunity to say a few words before we break for coffee. Please.
Hvala puno, poštovani predsjedniče, gospodine Spano. Moram da se samo nadovežem kratko na našu sutkinju Ustavnog suda, gospođu Lidiju Đukić. Da, taj slučaj je bio najinteresantniji, zapravo najveći predmet u našoj praksi. Samo da podsjetim, Poverenik za zaštitu ravnopravnosti je podneo inicijativu za ocenu ustavnosti. Jer smo mi tada dobili nekoliko hiljada pritužbi u istom danu i da je svakako izbegnuta ozbiljna katastrofa i jedna sistemska diskriminacija zbog toga što bi tada bile prinuđene da u penziju odu sve žene koje su radile u javnom sektoru, a to su pre svega bile lekarke, nastavnice, socijalne radnice, dakle u vitalno važnim javnim službama koje bi bile prinuđene da ode u penziju, one to nisu želele. Želim samo da kažem da, naravno, i pored toga što postoji i dalje zloupotreba od strane poslodavaca u privatnom sektoru, ipak je tadašnja odluka i prihvatanje privremene mere koje smo tražili od strane Ustavnog suda sprečena sistemska diskriminacija koja je mogla da se desi, a sada ti pojedinačni slučajevi koji se dešavaju nama jesu poznati, ali ipak to je daleko od svega onoga što bi se desilo da Ustavni sud tada nije proglasio odredbu neustavnom. Ali mi za sada nemamo informaciju da kada se nađe na apelaciji neki od tih slučajeva da je neko izgubio. Ako jeste, to bi zaista bio, ali to bi zaista bilo ozbiljno kršenje i odstupanje od sudske prakse. Za sada nam se nije niko obraćao, ali da, ovaj slučaj koji su naši susedi izneli, ovaj koji smo mi imali, je možda jedan od vrlo važnih i možda zaslužuje jednu detaljniju analizu zbog čega je to tako i možda jednu onako zajedničku diskusiju posebno u nekom, možda u sledećem panelu kada budemo imali neke primere iz naše prakse. Hvala.
Thank you very much, and let me recall that we will now have workshops following the coffee break that we will have in a moment, and I think indeed this is an issue which would be very much an issue for discussion when it comes to questions of gender equality and also under Article 8 and 14. Ledi first, maybe a few words, and then Ivana, if you have some concluding remarks, please, Ledi.
Well, very briefly, concerning Protocol 12, I very much join the concerns of the other speakers, and that's a tendency in the region. Also, is a question of mentality, if you want. Historically, international treaties accepted were thought not as something producing substantive and procedural rights within the domestic kind of proceedings. And there we have a struggle, and especially national judges, they have a struggle. So I understand very much the difficulty in that regard. As far as the employment and discrimination based on gender related to employment, of course I recall the principles in Fabian, although there's no gender issue as such, but they might be useful for the analysis. Or another case, which is gender discrimination and employment, I've gotten inspiration from Schiffer O'Leary, would be Defren versus Sabena in Luxembourg, which is 75, 76, something, kind of seminal case from the European Court of Justice, which concerns really gender discrimination in matters of employment. Thank you.
Pa evo ja ću biti kratka, kao što je i kolega Bianku pokušao da skrati, zato što već imamo dovoljno tema za razmišljanje. Želim samo dvije stvari da istaknem. Prva je da članovi 14 i 8 u kombinaciji mogu da pruže punu zaštitu i zaštitu rodne ravnopravnosti, prava žena. Kada tumačimo, mi sudije, kažem mi, mislim i nacionalne sudije i sudije Evropskog suda za ljudska prava i ostalih sudova, važno je vidjeti šta je svrha, šta je cilj prava. Mi, profesori, volimo da kažemo teleološko tumačenje u ovom kontekstu je na snazi. U početnoj jurisprudenciji Evropskog suda za ljudska prava srećemo se sa situacijom da kad god se o nekom pravu, pa evo pravima zaštićenim pod članom 8 raspravljalo, čak i ako sud pronađe kršenje, član 14 je ostajao po strani. I tu se koristila ona Kampeanu formula da o tome ne treba raspravljati. Sada sve više imamo situaciju da se, bez obzira na to da li je kršenje člana 8 ili dvojke, trojke, četvorke, i član 14 raspravlja. Rijetko se dešava da sud kao master karakterizacije upotrebi ono svoje pravo jura novit curia, pa da iako aplikant nije istakao svoje zahtjeve u odnosu na član 14, to upotrebi. Mislim da je svijetao primjer SM protiv Hrvatske. Mi nismo danas raspravljali član 4, ali sigurna sam da će na nekom od narednih foruma i to biti tema. I na kraju samo o margini procjene. Bilo bi lijepo da vidimo što više slučajeva gdje države koriste marginu procjene, slobodu procjene, da unaprijede rodnu ravnopravnost i osnaže prava žena. A kao što smo imali u praksi koju smo pomenuli danas, a ne suprotno samo. Često države koriste marginu procjene da ograniče prava. I to je trend, kao što je rekla Šifra, svuda. Nije to samo na Balkanu, ali ovdje je dramatičnije, jer su naše zemlje još uvijek u tranziciji ka modernim demokratijama. I mi bolujemo one bolesti koje su naše zapadne kolege prebolovale nakon Drugog svjetskog rata. Mi ih bolujemo sada, zbog svih ovih naših konflikata. Time ću završiti i tu smo, jel?
Thank you very much indeed, and I thank all the panelists and everyone who took the floor. We will now take a 15-minute coffee break, and then we will break into 2 thematic working groups.